195th webinar on opportunities for professionals in mediation. Friends, as you all know, our webinar series began in 2020 during the COVID pandemic, driven by the enthusiastic participation of attendees and the generous knowledge sharing by experts. Now, this support and eagerness to learn have motivated us to continue hosting these sessions every Friday from 4 p.m. to 6 p.m. without interruption. I must thank you for joining us, and we look forward to an engaging and insightful session today. Friends, before I start discussions on today's topic, I would like to announce the topic for our next webinar, which will be held on 22nd of October, as 15th of October is a public holiday. And it's a very interesting topic. The topic is leaning out and group consolidation for organic growth. Friends, coming to today's topic, today we will explore the new opportunities and possibilities that the Mediation Act of 2023 opens up for professionals, particularly company secretaries, chartered accountants, cost accountants, and advocates. Friends, you'll all agree with me that this newly enacted mediation law has the potential to fundamentally alter the dispute resolution landscape in India. We all know the pendency in court cases, the burden on the courts. There are about over 80,000 cases pending in Supreme Court of India. Around 60 lakh cases are pending with various high courts. And the number of disputes pending, litigations pending in lower courts is in crores, maybe 4.4 or 4.56 crores. Now, this new mediation law, as I said earlier, has the real potential to fundamentally alter the dispute resolution landscape in India. Resolving disputes early not only saves valuable time and money, but also fosters an environment that supports contract enforcement, creating a healthier commercial landscape. Mediation results in amicable solution of disputes in civil, commercial, and family matters, and fosters collaborative approach, reduces the burden on the courts, and preserves, that is the most important thing, relationships amongst disputants. The Mediation Act 2023 is a very comprehensive legislation, and it aims to promote and facilitate mediation, especially institutional mediation. This act provides for enforcement of mediated agreements. Also, this act very significantly has introduced online institutional pre-litigation and community mediation concepts. The Act also provides clarity on the mediation mechanisms and processes. It sets a structured framework for mediation proceedings, including, and very importantly, confidentiality and the formal conclusion of mediation. It seeks to promote mediation as a preferred mode of ADR The rising shift towards settling disputes through mediation highlights the crucial role of professionals, including chartered accountants, company secretaries, cost accountants, and advocates, in facilitating effective dispute resolution. The role may be in the form of acting as mediators or as participants like advisors, consultants, technical experts, or observers. This webinar today will explore how to navigate disputes more effectively through mediation, focusing on both the tactical and practical approaches to achieving resolution. As we stated in our announcement, the key discussion points for today's webinar are: we'll give a broad overview of the Mediation Act 2023, practical strategies for effective dispute resolution through mediation, procedural nuances and best practices in mediation processes, negotiation skills for mediated settlements, common challenges and overcoming obstacles in mediation, and what is the role and opportunities for professionals like us in mediation. Friends, we are indeed honored to have with us a very distinguished panel of experts on the subject, and I extend a very warm welcome to all our esteemed speakers. Friends, Mr. P. Nagesh is Senior Advocate, Supreme Court of India and Delhi High Court. He is a renowned corporate lawyer with over 26 years of experience in corporate laws, advisories, and litigation. He is a research-oriented person and has represented wide-ranging, complicated nature of corporate cases before the Supreme Court of India and Delhi High Court and NCLT. He is also Senior Vice President of the NCLT Bar Association, besides being closely associated with several trade and industry associations. I extend a very warm welcome to you, Shri P. Nagesh ji. Friends, then we have with us Mr. Amit Khemka, a certified mediator and practicing as a litigation lawyer in Supreme Court of India, high courts and other courts of the country. He has handled very large number of cases involving very complex issues, some of which have made headlines. He has over 38 years of experience and has also taken up many issues concerning the public good. Our warm welcome to you, Shri Amit Khemka ji. Welcome to the webinar. Friends, soon Miss Girija Krishnan Verma will join us. She is a certified mediator and arbitrator, a fellow member of the Certified Arbitrators Association, an accomplished legal professional specializing in dispute resolution, particularly ADR, commercial, corporate, investor or shareholder disputes, intellectual property issues, family and HNI succession plans, and matrimonial matters. She has successfully mediated and arbitrated about 250 plus cross-border transactions and commercial and intellectual property cases. We also have with us Mr. Ravi Prakash, who is an associate partner, securities law and corporate litigation, corporate professionals, and Mr. Siddhant Sekhri, an associate securities law and corporate litigation, corporate professionals. Friends, the proposed structure of the program is that we will start by requesting Shri P. Nigeshji to deal with the subject of negotiation skills for mediated settlements in commercial matters, followed by Shri Amit Khemka ji. Then Siddhant Sekri will give a detailed presentation giving the overview of the Mediation Act, followed by Ms. Girija Krishnan Verma and Mr. Ravi Prakash. May I now request Shri P. Nigesh ji to address us on the topic of negotiation skills for mediated settlements in commercial matters. Over to you, Nagesh ji.
Thank you, Agarwal ji. I hope my voices and audio is clear.
Yes, sir. Yes, sir.
Yeah. Good evening. Good evening, dear friends and professional colleagues. It's an indeed privilege to address you on a subject of profound importance amidst some of the stalwarts who are very much experienced in the field of mediation. We, as senior counsels, we only take our matters to the court and argue, but we have seen many of our cases being referred to mediation and successfully resolved. That gives credit to the certified mediators and mediators who are trained in this field of mediation and their skills. And today, the topic that I was asked to deliver or speak on is what are the negotiating skills for professionals engaged in mediation. And this, I basically, because I'm not a certified mediator, but I can tell out of my experience where I was involved assisting one of the groups before the mediators, and my experiences are borne out where the mediations failed and the mediation succeeded. Because the mediation succeeded, I could gather the skills the mediators had while concluding the mediation in a fruitful manner and to the benefit of all the parties. So I've jotted down some of the key negotiating skills, which in my opinion would be helpful for the professional mediators to resolve these commercial disputes, or for that matter, any other dispute being faced by the mediators. And in my opinion, the mastering negotiating skills is not only beneficial but very imperative, because India is a large, diverse cultural, social, and legal fabric, and we need to understand every aspect of the individuals or the corporates that turn out during mediation. So I broadly divided my topic into around 10 headings, which would more or less cover the skills which are required by every mediator for effectively concluding the mediation. The first one, in my opinion, would be what we call it is an active listening. The mediator should actively listen. And when I'm saying actively listen, it involves he should hear both verbal and non-verbal attributes from a party. Many a times, silence could also be an answer to many things which the mediator should pick up. Because he is listening to the parties, he should very carefully analyze why is this particular party suddenly silent. It could be a state of confusion, it could be a state of consent, it could be a state of dissent, which the mediator must understand. This skill of listening allows mediators to understand the underlying issues, identify the interests, and build trust. Basically, if you're listening to a party at length, it builds trust. And the party will be able to confide many more things, because he, at the other end, he's seeing somebody who's listening to him very carefully, attentively. And this gives a sense of confidence to the parties. So the first point would be that a mediator should develop a skill of active listening. The second point, since a mediator is person sitting there, some mediation where the mediators have shown a lot of empathy and emotional intelligence. See, this is also another trait which many of them may not have, but it is important. Why do I say empathy is different from sympathy? Sympathy is where somebody is trying to show sympathy to a victim. Here, there is no victim. Here, both the parties are before a mediator, and therefore, because there is a dispute, the mediator should show empathy, and that empathy flows from a lot of individual theory of empathy. This empathy helps mediators to connect on a human level. What is happening? You are not sitting there as though you are a professional. You are sitting there to resolve, and therefore you have to connect on a human level. What we call it bye. On a human level, if you connect, it will help facilitate a more cooperative environment. Because if you show empathy, they will like to share so many personal things also. Many of them which would not like to be seen in black and white before a court or before any other forum. They would like to share some specific and important aspects of the matter if you show them empathy. And this emotional intelligence, what we call it as emotional intelligence, allows mediators to manage their own emotions and understand those of the disputants, helping to de-escalate tensions and foster open dialogue. For example, one can cite some similar experience from their side also. Oh, if the problem is being heard, they can say, listen, I had a particular issue. We dealt with that. My grandfather, my parents, my great grandfather, somebody else helped them resolve this issue. That, like, we had that old panchayat system. So that shows the parties, oh, this man is like a human like me. He is not like a judge sitting and taking down a case. He is like me. So they would be able to convince the mediators. Showing empathy would be able to convince the parties in much better manner and handle and strike a chord with the parties. So therefore, the second attribute I would like the professional mediators to have is emotional and an empathy. This intelligence is very important. That will come over a period of time when you develop these skills. The third one, India is a broad country. So we have different religions, different parties, rich and poor, everybody. So the mediator should develop what we call it as a cultural sensitivity. The mediator should require he should be a culturally sensitive person. Understanding and respective cultural nuances is also very important, which will help him navigate the discussions. If you're having somebody from a different region of the country, like a south versus north or a east versus west, if you know the culturals of those parties, it will be easy for you to negotiate effectively and avoid any potential misunderstandings also. Say, for example, some customs may be good for a particular region, may not be that good for another region. So you have to navigate skillfully in those areas. So that is one of the aspects which I felt that they should be culturally sensitive. And of course, this is more in relation to the family matters. But as far as the what we call it is the corporate matters are concerned, this can take a sidestep. But by nature, I would rather require a mediator to be culturally sensitive. Then the fourth issue in the negotiating skills is what we call it as a problem solving skills. See, a person is sitting there to resolve a problem. He is not going to pass a judgment who's right, who's wrong. Unlike a judge, he's going to be a mediator. He's trying to resolve a problem. So mediation is also about finding solutions that satisfy all parties. So there we require strong problem solving skills, which enable a mediator to think creatively and propose options that address the needs and interests of everyone involved. Like, for example, he should swap the parties. Like, if the dispute is between two shareholders, one minority and majority, he should swap the parties and say, oh, let's assume for a moment the minorities become majority and majority become minority. How do we resolve this problem? So it becomes important. For example, I've seen many matters, for example, in operation mismanagement matters, I have seen many of the shareholders dispute being referred to mediation. And there, the problem solving skills of a mediator came to the fore, and he was able to resolve an issue. Let me give you an example in this personal example. The companies had two children, two sons were holding on to the majority of the share. Unfortunately, one of the sons died. and the wife of the son who inherited the shares filed the case of operation mismanagement, and there were disputes. They were all living in a what we call it is a family house somewhere in a big farmhouse, etc., which had a swimming pool, etc. So everything was sorted out. The daughter-in-law agreed for the money part of it, everything, but still the mediation was not going through. So that is where the problem-solving skills of the mediator came into the fore. He finally asked a simple question: why is that when you are getting money also you are not agreeing to it? So while discussing with the lady, he found out that she was attached to one particular part of the house. That was because her children grew from that place. So there was a swimming pool. So of course she didn't want to say that she wanted the swimming pool area to be given to her. But while discussing with the lady, the mediator immediately guessed that rightly. And he immediately said, okay, we'll do one thing. We'll give you the swimming pool also. The moment the swimming pool was agreed to, the matter got resolved. So this is quick thinking on the foot, and these are what we call it is the problem solving skills of the mediator, where he will anticipate what is that is coming in the way of a settlement. So he should be able to look into those aspects and resolve the issue at the earliest. Now, the fifth important aspect is this is, of course, goes to everyone. What we call it is a patience and perseverance. The mediator should have immense patience. It's a negotiation in mediation can be lengthy and can be a challenging process also. So, therefore, patience is a key. Mediators must be prepared for the time it takes to reach a consensus, and perseverance helps them keep the parties engaged and motivated towards finding a solution. See, if you cut short the conversation, if you cut short the mediation process, the parties will go back to the litigation. So the moment you show a lot of patience, the parties will say, okay, you are trying to find a resolution, you are trying to find a solution. So therefore, they will keep on talking to you, giving them their own problems, disagreements, agreements. So patience is a very important aspect. In here again, I'll give a personal example. In a typical, again, shareholders dispute, I was appointed not as a professional mediator. They said that why don't you negotiate with the parties? It was again a family company. The mother of the house, like the father, mother had 3 children. Father and the 3 children had the shares in a company. The eldest son took the father and the entire family to the court. And then you won't believe it took me almost 3 months to settle this matter. And finally, I could see one of the sons, the one who took the family to the court, was attached to his mother. So we went on for almost 3 months to settle, and finally, the way the whole matter got resolved is, I said only one thing. See, ultimately, she's your mother, and I told the father also, she's your wife. Why don't we give her 20% of the shareholding of the company? So finally, the entire 100% shares were divided into five blocks, and each one of them got 20%. And in no moment, but this was, I could gauge it over a period of time. I did not see this immediately coming. Father was vehement. I don't want to give any share to my wife. But then in the process, because of the patience I had in driving them the issue, saying that, listen, after all, this is your mother. So ultimately, shareholders dispute got resolved. So this is the patience and perseverance pays a lot in these mediation also. Next, the sixth important aspect is communication skills. The mediator should, while negotiation, should have excellent communication skills. And the mediators must be articulate, convey information, and facilitate discussions in a way that is understandable and respectful. I think the mediator should also be able to use plain and simple language. You should not use legal jargon, because mediation is where we are facing the parties. So the party should be spoken into plain and simple language, as if one is talking to a close friend. So good communication always helps prevent in misunderstanding and ensures that all parties are on the same page. So therefore, communication skills are also a very important negotiating skills in my opinion. And then the seventh point, I have seen people reposing faith in persons who, at the outset, they feel, of course, everything starts with what we call it is the concept of impartiality and objectivity. So the mediator, the moment he sits, he should give a kind of a body language that, listen, I'm impartial and I will resolve this issue with a lot of objectivity. So you have to, during the mediation, one of the key negotiating skills is stay neutral and be objective, and do not try to attempt or even by default try to show any bias towards any party. This impartiality will ensure that all parties feel comfortable. Oh, he is hearing me, and they will respect the mediator also. So therefore, what will happen? It will foster a fair and a balanced negotiating process. That's one important aspect. So it's impartiality and objectivity is one of the key elements of a excellent negotiating skills for a mediator to have. Then the eighth point, what I call it is a strategic thinking. Very important strategic thinking. Before a mediation starts, the mediator should know, he should have a clear understanding of the goals and potential outcomes in commercial matters. So it's better he understands the background of the parties, their position in the companies, their educational qualifications, professional, etc. See, if you understand all these basic things first, before you actually attempt to do a mediation, it will help you, because every person has his own choices, every person has his own taste, every person has his own kind of a thought process. So it's better to understand the background of the parties. That is very important. And for example, if he's trying to resolve, he should also give issues relating to tax. I'm talking about commercial matters. He should say, listen, if you want this particular issue to be resolved in your favor, there is this tax implication. Are you ready to face the tax implication? So if these kind of things are actually put to the parties, so this will give a fair idea for the parties, and it will result in a potential outcome being narrowed down. So this is where I'm saying he should have a strategic thinking. Mediator should be able to anticipate challenges, adapt to changing dynamics. So for example, laws keep on changing. So you should adapt to the changing dynamics, keep abreast with the latest changes in law, and guide the process towards a constructive conclusion. So this is the strategic thinking, in my opinion, is also very important. And therefore, I've seen successes in many mediations where I'm one of the counsels, where strategically some of the counsels, mediators, they thought out of the box and they had given a fair decision in the mediation process. Then, of course, the ninth, I'll have two more points before I conclude. What we call it is understanding legal and procedural frameworks. This is very important. And I'll tell you out of my experience again here. A thorough understanding of the legal and procedural framework is very essential. I'll tell you the reason. The knowledge ensures the mediators can guide the process effectively and ensure that any agreements reached are legally sound and enforceable. See, mediator cannot simply say in a shareholders dispute, oh, you transfer your shares, the other side transfer the shares, this is a consideration. Many a times there are pitfalls in their suggestion because they do not understand the legal and procedural framework. I'll give another example. Long back, before actually the what we call it is the formal mediation process commenced in India, we had one chartered accountant usually would say, okay, I'm ready to resolve the dispute between the shareholders of a company where it more or less involved the family companies. So what he did, one fine day, he transferred the shares and the properties of the companies. There were 10 companies. He transferred the shares and the properties of these 10 companies, and only the affected shareholders signed, and he did not make the company as a party to those documents. See, companies' properties were being transferred and sold without the company being named as a party to the document. And everybody signed, settlement recorded, everything. They were so happy. The other shareholders went to the court in one go. The whole document was set aside as null and void. So therefore, I'm saying the mediator should also have a deep understanding of the legal and procedural frameworks. If the mediator at that point of time knew No, if the company property was being transferred, the company should also be made a party. The mediation would have ended successfully. So this is very important aspect. And the last but not the least is, I think every mediator should build rapport and trust. He has to build a rapport and trust while negotiating with the parties. It creates a conducive atmosphere for negotiation. Trust is something which is what we call it as a cornerstone of successful mediation. If there is no trust, the mediation would be a non-starter. And it is built through consistent, respectful, and honest interactions. So, therefore, when he's interacting with the parties, there should be that element of honesty. They should see, oh, here is a person who's trying to negotiate for us on our behalf and trying to attempt resolution without we going to the court, without we spending considerable time of money on lawyers and fees, etc. So, this kind of a rapport building and trust building is one of the key negotiating skills of the mediator. So, in a nutshell, what I'm trying to say is that my experience, of course, there may be many other negotiating skills, but because of the time, I thought these were the 10 important negotiating skills which one should have. Primarily, there could be other skills also. These 10 primary negotiating skills are very important for a mediator to successfully conclude and resolve the issues. So, therefore, acquiring these negotiating skills is not just about enhancing professional capabilities, but also contributing to a more effective and harmonious dispute resolution process in India. As mediators, we have the power to transform conflicts into opportunities for understanding and cooperation. By honing these skills, we can pave the way for more just, equitable, and lasting resolutions. This is what I thought I should give my views on this. Thank you very much for your listening to me. Thank you. Thank you.
Thank you. Thank you very much, Nageshji, for excellent tips. The 10 skills you shared with us, which are essential for towards mediation or a successful settlement. Sir, one or two small questions. You've already given some examples and shared with us your own practical experience, but our participants believe that trust building is the most important thing to be able to reach any successful mediation settlement. So, how to build trust? What should be done to build trust between the mediator and the conflicting parties?
See, to build trust, he should not, by even default, say that some parties are known to him remotely or otherwise. He should straight away look into the problem at hand. Like we Indians have this habit of saying that, oh, I know you, I met there in some party, social party, etc. So, first of all, anonymity is very important. You should say, listen, I don't know anyone. The moment you know anybody, you should immediately tell them, listen, do you have any objection because so and so's distant relative is known to me, something like that. Because you have to, that's how you build the trust. You should not you've not revealed your identity to either of them, and tomorrow they will find out somewhere, oh, this particular gentleman is known to one of us. So therefore, it is better to be neutral as much as possible. That's how you build the trust. And knowledge, let me tell you, the skills you have, the party should know that we are before a gentleman who has enough skills to complete and resolve this matter. That's what these two things are very important, in my opinion.
Sir, Section 442 of the Companies Act is already existing, and you have the conciliation and mediation panels are also there. Now, this section is sought to be substituted by the new section where which will be mediation will be under the new law. What would be the difference? What difference will it really make? Because in both the cases, the reference has to be made by the adjudicating authority to the parties that you go for negotiation or you go for mediation.
See, in India, we still do not have, for example, NCLT or for that matter, any court, unless the parties agree, they would not send the matter to mediation. If one of the parties says, no, I still want to continue. So we are coming closer to where mandatorily it will be sent to mediation, and then if it doesn't work, then you come back to the litigation. But this aspect, I've not dealt much in this. I think Mr. Kemka would be able to tell on this, throw some more light on this. But in my opinion, mediation, like for example, today we have this mandatory mediations in commercial court. So therefore, these kind of things, if it happens, even in company matters. So I think before, like for example, the government is trying to amend or bring in some more provisions where under the IBC, the operational creditors, before you file a petition under Section 9, they want to send them to mediation first. Because there it will be easy to convince the operational creditor as well as the corporate debtor, very small amount, he will not get it if the company is admitted. Why don't you negotiate and complete it? So these skills are important. So therefore, from what we call it a formal mechanism, from an informal mechanism, the world is slightly shifting towards a formal mechanism of mediation. This is what is happening.
Thank you very much, sir. Thank you very much. And our participants have really benefited.
Mangesh ji, you were fantastic.
Thank you, Kemkaji, thank you. Thanks a lot. I'm here to listen to you also.
Not being a trained mediator and still having such insights, that's unusual.
Yeah, so nice of you. Thank you.
Friends, now we would like to listen to Shri Amit Khemka ji, who is a certified mediator and an advocate of repute, and he can take us through what are the common challenges which are faced by mediators and how to overcome those obstacles in mediation. Over to you, Amit Khemka ji.
Thank you, Agarwal Saab. Thank you, corporate professionals. Thanks for giving this opportunity to us. I must start with an admission. The mediation movement started in this country somewhere around 2008, 2007, 2008. And you'll be surprised to know that Delhi High Court was in the forefront. I mean, that was the first court where a court-assisted mediation center was established. Before that, there was one Mr. Niranjan Shah, who in Gujarat used to run a mediation center. And Mr. Shah was one of the first trainer mediator in the country. Before that, for mediation training, you had to go out of this country. You did not have. And this was when mediation is something which is born in India. This was the strange thing, that mediation is something which is being practiced from time immemorial by us. From Bhagwan Krishna, trying to mediate between the Kauravas and Pandavas, to you have many such instances. However, and that is why the admission I'll come.
Sir, unmute yours.
No, I am unmuted, sir.
Khemka ji, sir, unmute.
No, sir,
You're not audible.
Am I audible now?
Yes, sir, you are audible.
Unmute.
Agarwal ji, Kemka ji is audible. I think there's something with your system. Just double check it.
आपका चेक कर ले सर, उनके बाद अच्छे से आ रही.
Okay. So I always believed that we lawyers who have been part of a number of mediations, we have always been part of settlements, we get so many settlements done on our table. So what is this? What they are doing, training? What training will they give to people who have been in profession for 2 decades, 3 decades, 4 decades? So let me admit that for almost 7 or 8 years, I did not become a certified mediator because I thought that I don't need training. But then I am the son of a teacher. So my conscience told me that, look, there is never end of learning. So go and learn. So I joined one of the courses which was started by Delhi High Court Mediation Center. And Nageshji, you will be surprised that who were my classmates in that. Vikas Pava was my classmate. Anup Bagai was my classmate. So even these people must have thought the same way as I was thinking. That, oh, we don't need the training. But when we got the training, when we actually joined and when we listened to the distinguished trainers, the first thing we had to do was to do the unlearning. We had to unlearn what we had learned. We realized that the settlements which we were part of had a big role of our personality. Our personality was playing a big role. The clients already believed us, or clients already trusted us. Clients already knew who we are. Clients already thought that what we are saying is right. It would do good to them. So it was not a scientific process by which we achieved those results. There were many other factors which might have played in those settlements. And during the training, they told us few very, very basic things. Like one of the basic things which Agarwal Sahab took the point from Nagesh sir was to build the trust. And so, well, Nagesh sir told you that how you must and how important it is to build the trust. Now, I'll tell you how I do it. And probably that is exactly what Nageshji was also trying to say. The first thing I do is I introduce myself. I tell them that who am I? Why am I here? I tell them that, look, I am trying to give back to the profession which has given me something. Then I specifically ask them that whether any one of you knows me. Do I have any conflict of interest with any one of you? And during COVID, when we were having online mediations, I had added a drama also to it. I used to put down my mask, and so show my face. Okay, see me. Now, these things might look small things. And then I actually used to tell that this particular lawyer representing Mr. So-and-so is known to me for 12 years or for 15 years. Do you still have any objection? If you have, we will have another mediator appointed in my place. So from there, from the fact that you are an experienced lawyer, you know your subject, you do not intend to side with somebody, you want to know about the conflict of interest right at the word go. Then there is one very important tool which has been given to us during our trainings. And that is to tell the parties the importance of mediation, as to what is it which they are about to get out of the mediation. And what they are losing during the litigation. The first thing is the cost. So you have to we pump into the client, into the parties that look, every day you are litigating, you are losing money. It is costing you. While this process is not costing you. It is almost free. At least presently it is free. Because abroad you have mediators who charge like lawyers only. You know, there are professional mediators who only do mediation job. And there are mediation firms in the Western countries. You have firms specializing in mediation. We do not have yet in India, even after almost 15 years of successful mediation movement. So right now it is almost free for them. And we actually narrate as to how they are going to lose the money. That look, you are right now at the stage 1. There is going to be stage 2. There is going to be stage 3. There is going to be Supreme Court. So we actually give them the picture that look, if you don't do this, then this whole demon is standing in front of you. And that is how we try to impress upon them that look, it is cost effective. Then the other thing is, we ought to impress upon them that when we tell them during the opening, this is all happening, this mediation has not started as yet. The process has not started. We are just telling them. This is all the part of the opening statement which we give to the parties. So we tell them that look, I am not a judge. So many times parties will come and say, my lord, your honor. No. Even young lawyers start calling us that. So I interrupt them. I said, please, if you want to respect me, call me sir or call me by name. You can call me by Amit Khemka. I am your friend. Like he was telling that you have to come make a rapport with them. So this process starts even before I have heard their dispute. So I tell them that look, don't call me my lord. I am not your judge. Then I also tell them that I am not your advisor. Your advisor is your lawyer. You have a legal advisor. Please seek legal advice from him. Now it works two ways. One way, that I am telling them that look, I am impartial. And the second is, I am giving due importance to the lawyers. Most of the times, when the mediations don't succeed, I will not say most of the times, many a times, it is because of the lawyers. So, very frankly, with all due apologies to my own professional brothers and sisters, I have to keep them in good humor. And I have to tell them that, look, you are important. It's not that just because it's a mediation process, your importance is not diminished. I will need your help. Your client will need your help. So we impress upon the parties that, look, it is party-driven process. It is not a process where someone else is going to decide your fate. In the court, it is the judge-driven process. It might be lawyer-driven process. This process is not driven by the lawyers and judges. It is by the parties only. It is you who is going to write your own judgment. You are going to write your judgment, not the judge. And then the last but not the least, to tell them that it is final. That once you write this judgment, you will have peace of mind. There'll be nothing called an appeal or Supreme Court or whatever. So, but if you have a judgment through this process, then in that case, you will have finality to your litigation. Then we also tell them that it is a win-win situation. Both the parties are the winners here. There are no heartburns. When a judge gives a judgment, there are heartburns. The vengeance is not satiated. The egos are not satiated. So we not only tell them during the opening statement itself that, look, you are going to have, you will be the winner because you are the writer of the judgment. And both of you are going to be the winners. None of you is the loser. Then we also tell them how the process will go on. This again is happening in the very first statement. Parties have yet not started speaking. So we tell them that, look, you are going to be civil. Even though you have sentiments, but you will not allow your sentiments to overpower you. You will not use bad language. You will not use unparliamentary language. You will not raise your voice. You will not, whenever I tell you to stop, you will stop. You will not raise your voice when someone else is speaking. You will allow the other person to speak. And that sets the tone. Then we also tell them that this process is confidential. And I give them the example that even the judge who has referred you to us cannot ask me as to what transpired here. That is the confidentiality attached. And even if any one of you records something during this process, it would be inadmissible in evidence. So when I tell them this, it allows the parties to actually come out freely. What they can't speak, what they can't tell the court, they tell me. And then I added by saying that, look, if you do not want, whatever you want to say in front of the other party, say it. But if you do not want to say something in front of the other party, I will request the other party to excuse for a while. And then you can talk to me in confidence. You can tell me what you don't want to say in front of the other party, and I will disclose only that much to the other party as you permit. All this happens before I listen to them. So all our senior mediators, every time they try to impress upon the importance of the opening statement. Because as Nagesh ji said, the first job of the mediator is to build trust. And as Agarwal Sahab rightly picked up the most crucial thing out of it, this opening statement helps us building this trust, setting the agenda, setting the momentum for the mediation process. Then the next thing I do is to take introduction of everyone. Even if it is a counsel assisting Nagesh sir, there I will give full importance to even his junior. Every counsel or every party present there, I will talk to them, I'll ask them. I will not object if some friend has come, if a non-party has come. Rather, I will, if someone else is objecting, then I tell them that, look, it is informal. If required, we will request that person to get out, but let him be here. Because we understand that not everybody can even express himself or herself. Many times the parties are at litigation because they have not been able to express. So they need some kind of a personal support. Somebody will bring a relative, someone will bring a friend. So all these kind of things keep on happening. And we have to absorb that. If we do not absorb, we are derailing the process. And that is how the congeniality in the atmosphere has to be brought. And then I ask them as to which one of you who will like to speak. Personally speaking for myself, I tell them that I will prefer that parties speak. If there is anything left, then the lawyer may supplement it. But sometimes when the parties say, no, my lawyer will speak, or the lawyer says, no, sir, I will speak, then I allow them as well. But then, as Nageshji said, that a mediator ought to be a good listener. There is so much the party wants to say. They want to abuse the other person. They want to, the other party, they want to say so many things. So even if you have to talk in caucus, you have to allow that to happen. हम बोलते हैं हिंदी में भड़ास निकालना जरूरी है. Till that happens, till you have given the allowed the person to give vent to all those stacked up feelings. So most of the times, our first meeting is opening a statement plus giving vent to the feelings. Then, as he very beautifully said, that you have to identify the issue and separate it from positions. Parties have taken positions. But then you have to identify issue kya hai? What is the actual issue? And one very beautiful thing which we were taught during training was repeated summations. During the process, you keep on telling them, मैंने सही समझा? Have I understood you rightly? This is what you mean to say. So this person, what you are doing in the process is that you are making him understand his own problem. most of the time his own problem is clouded, his own mind is clouded. So this repeated summation plays a very, very big role. I have found the opening statement and repeated summation to be the most important tools in mediation. It looks very strange that for 15 minutes in the beginning, you are giving an opening statement to the parties. Sometimes it might look boring, but then it sets the agenda. It makes them think. Similarly, repeated summations also makes them think. A mediator cannot be in hurry, as Nageshji rightly said. A mediator ought to be patient. And that includes adjourning the matters, adjourning the meetings for parties to rethink, for parties to, whatever has happened today, let them also rethink about it. And how beautifully he said that we should not even subconsciously give our opinion. Because हम तो इंडियन है, हमारी तो हर चीज पे ओपिनियन होती है और उसके ऊपर से वकील हैं. So there can't be any subject on which we don't have an opinion. So that is why I said that during training we were taught to unlearn what we have learned. And we were told not to give your own opinion. And let me tell you, whatever benefit it might be to the litigant, whatever benefit this process might be to the legal system, the first beneficiary of this whole system is the mediator himself. Your personality changes after the training. You start feeling that you are a different being. You are a different person. And that is why Girija has been with me in many trainings. We have been classmates in many of the trainings. And of course, I can't match her. We can't wait to listen to her. She is a wonderful human being and a wonderful, mediator. Much more accomplished than me. So I think I'll not be in between Girija and the participants, and we will like to hear her. Thank you so much, Agarwal Sahab. Thank you so much, corporate professionals. Thank you, Nageshji, for being there. And thank you, Girija. We are very eager to listen to you.
Yeah, thank you.
Agarwal Sahab, you're muted.
Yeah. Khemka ji, just one small question before I request Girja ji to speak. Sir, you must have handled situations where there is emotional or tense situations. How do you handle that?
Take it in stride, sir. So answer, I don't think mediator does something extraordinary for that. It's all patience you have to show at that time. Every elderly person or every mature person, how the way that person will do, and every mediator will do the same thing. And I think that only benefit we get out of that is that we are able to identify the problem a little more. Because when a person is agitated, he actually sometimes speaks the truth as well. So you have to be very careful at that time and watch how these people are behaving. So, but again, as Nageshji cautioned, we don't have to judge. I cannot, as a mediator, judge. I have to only provide a platform to the parties to reach their own judgment. Thank you, Agarwal sir.
Thank you very much, sir. Thank you very much. Now, may I request Ms. Girija Krishnan Verma to take us through the practical strategies for effective dispute resolution and the procedural nuances and best practices. Over to you, Girija ji.
So thank you very much to corporate professionals and Agarwal ji to give me this opportunity. And I must thank Nagesh and Amit for the wonderful presentation. I had a lot to learn from them, and I can see very much that, I missed a lot of the nuggets that were given in the, training sessions, which I've now been able to pick up after their presentations. And so thank you so much. And thanks for the wonderful introduction, Amit. That's really helpful, I think. Thank you so much. So I think a lot has been covered, but I'm just going to quickly say a little bit about the law and, and then also do some, maybe speak a little bit about the procedural aspects of mediations and how we are seeing different mediations now. So some of the sections of the law which are, promoting mediation is, as we know, the previous sections were Order 23, Rule 3 of the CPC, then Section 89 of the CPC. These are, sections which help parties to invoke mediation at any point. There's Rule 4 of the ADR rules of 2003, which has mediation processes. Then the Arbitration and Conciliation Act of 1996 has provisions for conciliation, mediation, private mediations as well. It gives, more sanctity to the settlement agreement because it's almost treated as at par as an award or a court decree thereafter. Section 12A of the Commercial Courts Act of 2015 is important because now they encourage pre-litigation mediation for most commercial disputes, which are above rupees 3 lakhs. And as an IP lawyer also, I see that IP is a part of Commercial Courts Act, and even in IP disputes, a pre-litigation mediation is generally encouraged. Then the Commercial Courts Pre-Institution Mediation and Settlement Rules of 2018. There's also, which makes it compulsory, pre-litigation is compulsory. Then there's commercial disputes, then there is a Legal Services Authority Act of 1987. Now we see some new acts, new sections in previous acts, which is the Consumer Protection Act has a section for mediation. The MSME Development Act of 2006 is a very important act for new entrepreneurs and MSMEs, where they encourage mediation. The Companies Act of 2013 has also encourages mediation. Then there are some jurisprudence and judgments of the Supreme Court which now say that pre-litigation mediation is important. These are generally the processes where parties can invoke mediation. Now, the recent act, bill that is yet not passed, but has many sections which also encourages mediation. But one of the important things is that they're trying to institutionalize mediation, and that may be important from a process point of view because institutional mediation, I think, has brings in more sanctity to the whole process and more legalities to the whole process. It is also very helpful because firstly, if there's an institution, they can have a panel of mediators who are skilled and also technically skilled mediators and also technical experts, which can help in the mediation process. So the institution can help in the appointment of mediators and experts as and when required. It can assist in uh, fixing the consultation fees as well of the parties as well as of the mediator and the administrative expenses in the mediation process. It can it administers the financial aspects of the mediation by obtaining a deposit from each party for the mediator and any other support services that are required or facilities that are required. An institution can help in setting up the venue, meeting and waiting rooms, which are helpful for the mediation process. It assists the parties in organizing any other support services that may be needed, such as translation services, interpretation, or secretarial services. It can it can ensure that there is a proper disclosure by the mediators for any conflict of interest issues. It enables a resolution which is quick and efficient manner, which is often during the lifetime of, mainly this is mainly for IP disputes because they are IPs which have a registration period or a validity period. So yeah, the mediation institution can help a quick resolution and also help in getting together documentation and information gathering, which may be necessary to determine the factual position between the parties. I think institutional mediation also helps in cross-border disputes because very often there are parties sitting, foreign parties are sitting abroad, and there are issues that are happening in the Indian markets. So to handle those disputes, an institution can enable the process both from a technology perspective and also from identification of the mediator. And finally, I think it can ensure compliance of the code of ethics by the mediators, which is very, very important. It can ensure that there's confidentiality that is maintained in the process of mediation and thereafter. And also, they can help in the stamping and authentication of the mediated settlement. So broadly, these are the processes which an institution can help. The other side is the negative side to having an institution is some mediators feel that it takes away the flexibility from the process or it takes away the creativity from the process and it's kind of putting the whole process in a very streamlined manner. Well, I would say that since from personal experience, I've done, privately run cross-border mediations as well as through the Delhi High Court Mediation Center. I think the assistance you get from the institution is far greater and it helps the process in a much better manner. And it also, gives the parties confidence that there is a institution backing this whole thing. So that kind of helps the whole process, I think. So it's important that there's an institution, but yes, I do feel that the mediator's flexibility and creativity should not be curtailed by any sections of the law because that's the charm of mediation. I mean, if you look at it, we have sufficient number of rules and regulations to handle arbitrations and litigation. So I think this should be kept free from those rules and regulations. I think a code of ethics is the most important thing, which is, which can be enforced. So broadly, that is what I have to say about the processes. And if there are any more questions that parties have, I'll be happy to answer them. Thank you. Thank you very much. Agarwal Saab, your mic is muted.
Girija ji, since you have so much of experience, can you share with our participants what are the best practices for drafting and finalizing a settlement mediation document?
Yes. I think that's a very key, a very important question. And I think some of the important things that you should bear in mind is that whatever there is in the sections, firstly, especially in some disputes which might have, you have to put on some information, then you ensure that the confidentiality is somehow maintained and that information is put across in a very subtle manner. Of course, if both parties agree to reveal it completely, then it's a different thing, then it's fine. But I think confidentiality should be maintained in that. Then you should ensure that try to see that all litigation is closed and there are no future issues that are left open as issues uh, post the settlement agreement. So, as far as possible, this should be the final and binding document, as even Mr. Amit Khemkaji said that this should be final and binding in some ways. And sometimes, of course, parties insist on a penalty clause in case the enforcement doesn't happen properly. Personally, one feels that, that's open to Pandora's box, but I think to give comfort to the party, sometimes you can agree to a clause like that. And then, of course, withdrawal of all litigation and no further issues on that particular dispute should be left open. And there should be withdrawal of all litigations and any pending applications or, uh, uh, you know, uh, disputes that are open should be closed. Then you can see that how you can get the settlement agreement enforced. It should be enforceable. It should be a workable document. So, for example, there may be a property dispute, and finally they decide that, okay, um, the will would be executed subsequent to on a certain date or whatever, or the will is being executed. Then you ensure that all the documentations that have to be signed along with that are also included in the process so that nothing is left open. And also in terms of any payments that have to be made, post the settlement also, if there are any payments to be made, how do you ensure that those are enforced and they are not, subject to being left open again and not being adhered to by the party? So try to do that. In some settlements, people still, go ahead and say that there should be a dispute resolution clause in case somebody doesn't, enforce this agreement, which is, those people who are very, very not trustworthy of the process. Then you may have a clause which says that, yes, okay, I would generally encourage arbitration for that, but some people could say no, they may go back to court for litigation. So it's, it depends on the parties and how you work it out. But I'm reluctant to do that because you feel that, it's not a closure, complete closure. But anyways, that's a way that parties go ahead. So I think that clearly covers everything that you want in a settlement agreement.
Thank you. In fact, I think the new law.
Let me
will take
add
care of
something.
this.
Agarwal sir, I want to add something to that.
Yes, sir. Yes, sir.
See, I tell you that in the beginning of this mediation thing, somewhere around 2011 or 12, I saw a settlement wherein two brothers entered into a mediation settlement in respect of the ownership of a DDA park. And that agreement went to the court and court converted it into a decree.
Oh God.
I might be having a copy of that. So what mediator has to keep in mind is that mediators are almost trusted blindly by the court. The courts, they think that now mediator has done it, so we don't have to apply our mind now. So mediator has a responsibility that law is followed. There is nothing wrong with the agreement. And as Girija said, that it is enforceable in law. And what Delhi High Court Mediation Center Samadhan has done, that even after we have settled the mediation agreement, it actually goes to a committee of mediators. They approve it, and then only it goes to the court for final decree. So this job is a very, very responsible job, which mediator has to oversee, and he has to see that nothing is illegal with that agreement. Thank you.
Thank you.
Thank
Thank you. Girija
Thank
ji, what do you feel? How is mediation better than arbitration?
Oh, full session in itself, but in short, I can quickly say that, of course, they are very completely different processes. Arbitration is adversarial, mediation is more amicable. Arbitration has issues on jurisdiction, they have issues on maintainability, which mediation doesn't, you don't have to thrash out those issues. Then, well, both are time bound. Mediation has a shorter time period as compared to arbitration, which has a longer time period. And the outcomes are different. So, for an arbitration, it could be an outcome which the judge decides for you, whereas in mediation, it is the parties who decide their own outcome. So that's the primary, reason why people opt for mediation, because they have control over the process. The outcomes are what they decide is theirs. And I think you can mediate anything under the sun. You can almost mediate anything, anytime, anywhere. Whereas arbitration has a set of rules and regulations, and being an adversarial process, it has to be very formal and evidence based. Whereas mediation is completely different. You don't look at it from the legal perspective at all in some ways. You go beyond that, and I think the scope of mediation is much wider than any other form of dispute resolution.
See,
So
otherwise, I'll just add one more thing. The mediation ends the litigation. The arbitration award does not end the litigation. If I may say, it actually starts. You can file objections against the award, then you can file appeal against that, then you can go to the Supreme Court. So you have at least 3 more opportunities to litigate, even after an arbitration award. So to call arbitration ADR itself is questionable now. Thank you.
Thank you very much. Thank you very much, sir. And thank you very much, Girija ma'am, for excellent exposition of the subject. May I now request our young budding advocate, Siddhant Sekri, to take us through very quickly, give an overview of the new law on mediation. Over to you, Siddhant.
Thank you. First of all, I must say, and I must thank all the senior panelists, Agarwal sir, Nagesh sir, Amit sir, and Girija ma'am, for their valuable inputs. And I must concede very candidly that I planned on going through my material during the course of this webinar, but I was so lost and so blown away by their inputs that I could not go through the go through the material which I had prepared myself. But anyhow, now I'll share the screen, and I have a small PPT prepared for this topic. I hope my screen is visible.
Yes, yes.
So, our topic is opportunities for professionals in mediation, and I will be particularly focusing on Mediation Act 2023. However, before moving to that, I would like to address what is mediation and the history and evolution of mediation. So, firstly, what is mediation? Mediation is a voluntary process, voluntary confidential process, where a neutral third party assists disputing parties in reaching a mutually acceptable solution. Now, there are some keywords which the learned senior panelists have highlighted. First of all, it is a voluntary process. It is upon the parties whether to go into a mediation or not to go into a mediation. Secondly, it is a confidential process. That is the confidentiality of the mediation, its proceedings, what happens therein, all has to be maintained very carefully, and it is responsibility of the mediator as well as the parties to maintain this confidentiality. Further, nobody can take advantage of what has taken place in mediation outside of those proceedings, as Khemkar rightly pointed out. Then very importantly, it says a neutral third party. Now, this is a core of the mediation proceedings, that the third party has to be neutral. It can't be a biased party. It can't be a party which has a conflict of interest. Any such conflict of interest has to be disclosed, first of all, and then it has to be either waived. And if it is not waived, you have to go with another third party. And this third party is the mediator. And yes, then we have disputing parties who would like to arrive at a mutually acceptable solution. I must point out that Girija ma'am very rightly said that in mediation, parties decide for themselves. That is why this term mutually acceptable solution. Moving on, you see, the history of mediation is, we have a great history of mediation, if I may say so. It is not something which has started in past 10 years, 20 years, 50 years, and it is ingrained deeply into our own system. So first of all, we have the example of ancient Israel, where King Solomon in as early as 960 BC used to mediate disputes. Now there is one very famous story which I would like to which I would like to tell everyone. There is this story of two disputing mothers. So what happened was, one woman killed her own son, killed her own child actually, and then she started claiming that the child of another woman is actually hers. So both of them were claiming motherhood of the same child. It went to King Solomon, and initially he suggested a very harsh step. He said that this child should be divided into half. The top half be given to the first mother, the bottom half be given to the second mother. It sounds very absurd, but we must take note that we are talking of ancient times. So this was suggested. However, the second mother, who was the actual mother of that child, said that let that child be given to the first woman. So although this example seems very absurd in context of what we have at the moment in terms of mediation, both in India as well as internationally, but this is how we can understand that in mediation, decisions are taken by the parties themselves, and the mediator only acts as a medium to reach to those decisions. Then we have the example of Sumerian society. So in the ancient Mesopotamian civilization, the mashkim helped resolve disputes without court intervention. Mashkim was a person. So the concept of pre-litigation mediation that we are speaking of in today's time actually evolves from the ancient Mesopotamian civilization, where mashkim was an institution, was a person who was there, who would listen to the disputes before they were referred to the court. Then in the Sumerian society also, as well as in the ancient Islamic culture, in Sharia law also, there was a there was people used to go to mediation, and it was mandatory for them to mediate their matters before they get into court proceedings. Then we also have the example of China. We all must have heard of the philosopher Confucius. That is why the Confucian philosophy valued ethical reconciliation over legal conflict. So what Confucius had in his philosophy, he said that the mutual respect for each other trumps the supremacy of law. He said that if you and me, we can decide that we want to proceed with a particular thing, that can go beyond the law. We do not need to abide by a particular law, a particular procedure to go about it. We can decide it amongst themselves and proceed so as to avoid conflict. And for this, he said that ethical reconciliation must be done. And then we come to the example of India, of course. In India also, we had the panchayat system, and where a sarpanch was there, and with him there were four other members. They were the panchayat, and they would decide and help mediate decisions amongst people. So all of this is a part of the history of mediation. Now, if we come to the evolution of mediation, I would first address it internationally and then come to the Indian context of Indian evolution of mediation in India. So first of all, the English common law integrated mediation as the preferred method of dispute resolution. And why is it so? Because we must understand that English law was based on, as it is also mentioned, it is English common law. For all those people who don't know what is common law is law based on precedents. So many would ask that if there is no written law, there is no written statute, how would a court arrive at certain decisions? So it would be based on two things. One is, of course, moral and ethical propriety. And second is, what is the culture? So based on these two things, the common law system was propounded, and it has functioned over the years in English law. So mediation was a very essential part of this, and their days were designated as love days, where only mediation would be done. No adversarial proceedings would be undertaken, and only mediation was undertaken in these days. Then I come to decline of mediation. So what happened was, you see, when I speak of English common law, this is a system which was developing over the years. In 1700s and 1800s, English common law was developing. But there came a point when there were legislations, law was developed. Even when we speak of common law, precedents were actually developed. So now you have something to say on, say, contracts or some commercial dispute. So people know what is the law, what is existing. So most of the times people would prefer to go to the court and argue out these disputes and get into litigation than get into mediation. It is also linked to the human ego, that people would like to show someone that I am greater than you. That is where mediation started declining and litigation started taking the fore. However, all of this changed in the US civil rights movement, which was in the 1960s. In the civil rights movement, community mediation came into the picture. Now, community mediation is another very important factor of the new Mediation Act 2023. So this also arose in the US civil rights movement. And in the US civil rights movement itself, I come to my next point, which is the Vietnam War. So Vietnam War also prompted social activists to explore alternatives to conflict, which led to evolution of participatory democracy and community mediation initiatives. In fact, one of the leading proponents of this was Ray Chenault, who established the San Francisco Community Mediation Board. And through this model, many community mediation programs were done. And this further propelled mediation into the mainstream. And now, what propounded it further were the Wolf reforms. Wolf reforms were introduced by Lord Wolf, who became the Lord Chief Justice of United Kingdom. And he said that mediation is a significant component of civil justice reform. And he used three terms which were to be addressed through mediation: costs, delay, and complexity. He said that if we solve our disputes through mediation, firstly, we'll save our costs. We don't have to pay lawyers. We don't have to make applications or pay court fees and all of that. Then we'll also prevent delay, because what can be solved through an amicable dialogue will always take precedence and will always be a more peaceful process as compared to a court process, which is bound by strict procedures and and that makes it delayed. Thirdly, it also prevents complexity. There would be, as I said, there are procedures, fixed procedures in courts, and that are bound to complicate the matter at times. Therefore, he said that mediation as a component of civil justice reform would address costs, delay, and complexity. Now, when we come to India, I think many of these have already been covered by Girija ma'am, and I'll just quickly brush over these. First is, of course, the panchayat system, as I earlier pointed out, which was a method of institutionalized mediation in India. Second, we have the Industrial Disputes Act. Now, very importantly, Industrial Disputes Act provides for a conciliation procedure. However, I have included it herein because this has paved the way for alternate dispute resolution mechanisms. Now, after the Industrial Disputes Act, we had the Legal Services Authority Act, which established Lok Adalats and permanent Lok Adalats to address the minor disputes of the parties, which can be settled by them without getting into adversarial proceedings or adversarial litigation. After the Legal Services Authority Act, we had the establishment of Justice Malimat Committee in 1988. This is the 129th Law Commission. And in this Malimat Committee report, it was recommended that alternate dispute resolution should be introduced and should be propagated amongst the masses to reduce the burden on the courts. As a consequence of this, eventually, an amendment was also brought in Civil Procedure Code in the year 1999, by virtue of which Section 89 was inserted. So, under Section 89, mediation has been given as an option for out-of-court settlement. And thereafter, we had several other developments, which ma'am already covered, which included the Commercial Courts Act, the Consumer Protection Act. Also, what Khemka sir covered is court-annexed mediation centers, which were established starting in 2005, 6, 7, in almost all high courts and all courts of this country. And all of this has led us now to the Mediation Act 2023, which aims to make the institutional mediation mechanism more concrete and introduce a statutory framework for the same. So now I come to the Mediation Act 2023. So first of all, I wanted to call out and show you all the preamble of this act. And I'll read it out for everyone. The preamble says, an act to promote and facilitate mediation, especially institutional mediation, for resolution of disputes, commercial or otherwise, enforce mediated settlement agreements, provide for a body of registration of mediators, to encourage community mediation, and to make online mediation as acceptable and cost-effective process, and for matters connected therewith and incidental thereto. Now, I have stressed a few words. First is promote and facilitate mediation. Second is institutionalization of mediation. Third is resolution of disputes, commercial or otherwise. So it has not bound itself to only commercial disputes or mediation of commercial disputes. It has kept its ambit wide and said that commercial disputes or others can be resolved hereunder. Then we have enforcement of mediated settlement agreements. So it has been a norm that even after settlements and mediations occurring, parties do not agree to it and parties do not let it be enforced. Okay. So enforcement of mediated settlement agreements is one of the most important and intrinsic feature of Mediation Act 2023. Then it also provides for body for registration of mediators. This is linked to the institutionalization of mediation. It also provides for community mediation, which we'll talk about later, and also online mediation. Everything is turning to audio-visual online modes, and therefore online mediation has also been taken into account and has been integrated into this act for having a futuristic outlook. Now we come to definition of mediation, first of all, which is provided under Section 3H of the Act. It says mediation includes a process, whether referred to by the expression mediation, pre-litigation mediation, online mediation, community mediation, conciliation, or an expression of similar import, whereby parties attempt to reach an amicable settlement of their dispute with the assistance of a third person referred to as mediator, who does not have the authority to impose a settlement upon the parties to the dispute. Now, very importantly, this is similar to what I had mentioned as the definition of mediation earlier on in my presentation. It is a process, and it can be referred to by any name, be it mediation, pre-litigation mediation, online, community, conciliation, or any expression of similar import, where the parties are trying to reach an amicable settlement with the assistance, now this is very important, with the assistance of a third person. And that person should not have the authority to impose a settlement. That is, that the person should not have a power to coerce the parties to enter into that settlement. Therefore, again, I would avert to what Girija ma'am said, that is that the parties have to decide for themselves. What the mediator has to do is to facilitate and assist those parties. And in this, I have broken down this definition into all these parts, which I just spoke about. Now it becomes very important to see what does not fall within the purview of mediation under the Mediation Act. For this, we go to section 6, read with first schedule of the Act. And the first schedule provides a list of things. I have tried to fix them up in one slide itself. But of course, I would recommend everyone hearing this webinar to refer to the first schedule for a complete list. It includes disputes against minors, persons with intellectual disability, or persons of unsound mind. Then it also excludes prosecution of criminal offenses. That is to say that prosecution of criminal offenses cannot be mediated. Thirdly, complaints or disciplinary proceedings against practitioners. So, for example, any disciplinary proceedings or complaints against advocates are dealt with by the Bar Council. All these proceedings are to be dealt with by the Bar Council only, and these cannot be mediated. Similarly, for medical practitioners and all other practitioners, all those proceedings are away from mediation. Fourthly, disputes affecting rights of a third party, which is not privy to the mediation. So any third party who would be affected by a particular dispute and who is not a party to the mediation, such disputes cannot be referred in mediation. Either you make that person a party or you do not refer these disputes. Now, there is an exception to this, that is disputes which affect the rights of a child. Those disputes may be referred to mediation. Next, any dispute relating to levy, collection, penalties, direct, indirect tax refunds. So this is with respect to tax laws, because all of this is governed by the Income Tax Department and the tribunals formed under the Income Tax Act. So all these are out of the purview of mediation. Next, we have proceedings under the National Green Tribunal Act, Electricity Act, Telecom Regulation Authority of India Act, PNGRB Act, SEBI Act, and Competition Act. So these are again specialized tribunals with specialized bodies with specialized powers. And therefore, these matters are not to be mediated. Although I must say that in many of these cases, mediation and settlement methods have been formed. For example, SEBI. In SEBI, there is a separate regulation called the Settlement Proceedings Regulations, which provide for settlement. And therefore, it is in itself a method of alternate dispute resolution. But all these specialized legislations are kept out of the purview of mediation. Next, we have proceedings with respect to land acquisition. Moving on, we come to the definition of a mediator. Defined in section 2I, mediator means a person who is appointed to be a mediator by the parties or by a mediation service provider to undertake mediation, and includes a person registered as mediator with the council. Now, the important thing in this definition is the two modes of appointing a mediator. It can be appointed either by the parties or by a mediation service provider. Now, what is a mediation service provider? We'll come to that in the in this presentation itself. Now, what are the qualifications of a mediator? As per Section 8, a mediator can be of any nationality. Parties can agree upon the name of the person to be appointed as the mediator. They may also agree upon the procedure for appointment. In case no decision is reached, they can apply to the mediation service provider for appointment. Once such an application is received, the mediator has to be appointed within 7 days of the said application. And if there are multiple mediators on the panel of the mediation service provider, the parties would have the preference to select the mediator from that particular panel. That is to say, the appointment of mediator from the panel is the prerogative of the parties. Now we come to a very important part of Mediation Act, which is conflict of interest. Conflict of interest means that any personal, professional, or financial, or otherwise any inkling which the mediator has with respect to one of the two parties. Now, this is very important because if mediator is not unbiased, there is a tendency for the mediator to lean towards one party, and this would lead to conflicts further because the party would go on challenging that the mediator was not fair, the mediator was not unbiased. And therefore, conflict of interest has to be addressed at the very threshold. And for this, the Mediation Act has made provision as such. So if any mediator has any personal, professional, financial, or other conflict of interest, he has to disclose the same to the parties before the mediation. In case a conflict of interest arises during the mediation, even then the same has to be disclosed to the parties immediately. Once the parties are aware of this conflict of interest, they have two routes. One is to take express waiver, that is to waive off the conflict of interest. The second one is to remove the mediator and make the application to the mediation service or make the application to the mediation service provider for his removal. Then a new mediator may be appointed. Now I come to another important part of the Mediation Act, that is pre-litigation mediation. Pre-litigation mediation, as provided in Section 5, is that the parties, before filing any suit or proceedings of civil or commercial nature in any court, may voluntarily and with mutual consent take steps to settle the disputes by pre-litigation mediation in accordance with provisions of this Act. Now, the Mediation Bill of 2021 sought to make this a mandatory step for all disputes of civil and commercial nature. So in the Mediation Bill 2021, the language was not the parties may voluntarily and with mutual consent take steps to settle the disputes. It was shall take steps to settle the disputes. However, the Parliamentary Standing Committee recommended that it should be made voluntary after it took recommendation from the stakeholders and from members of the society. And it has led to divergence of views because people say that voluntary mediation, who are in favor of voluntary mediation, they would say that mediation itself is a process which has to be left to the parties. As we have said time and again, that mediation is a process whereby parties decide their own fate. So if parties are to decide their own fate, it has to be left to them whether they want to enter into the very process or not. Those are the proponents of voluntary mediation. And then those who are against voluntary mediation say that it is a hindrance, an obstacle to institutionalization of mediation. So I will leave the audience with which mindset they would like to take. But at the moment, the process of pre-litigation mediation is voluntary. Now, what is the effect of a mediated settlement agreement? First of all, a mediated settlement agreement is final and binding on the parties. as I pointed out earlier, many a times parties would not abide by many mediations, many settlements. But the Mediation Act has made sure that the mediated settlement agreement is final and binding on the parties. And more importantly, it is enforceable in accordance with provisions of CPC. That is, it can be executed as if it were a judgment or decree of the court. And once a mediated settlement agreement is passed, it may be relied upon by the parties or persons claiming through them. Next, we come to challenges to the mediated settlement agreement. Now, this portion is very short and has been intentionally kept short and precise by the legislators. Why so? Because they did not want a mediation to be attacked from all ends. An open-ended provision to enable challenging the mediated settlement agreement would cause the mediated settlement agreement to be challenged every time. So there are only 4 grounds succinctly provided. First is fraud. That is a fraud played by a party upon the mediator or during the mediation proceedings. He may not disclose some document. He may not disclose some pertinent information which has to be disclosed. That is one. Second is corruption. As everybody would know, corruption means that you probably bribed the mediator, or you probably said to the other party that uh, I will give you a certain benefit later, but refuse to give that benefit at a later stage. That is a corrupt practice. Now, how this corruption is to be construed is to be left to the judicial interpretation, which will occur in a few years. But at this stage, it can take various forms. Then we have impersonation. A person impersonates to be someone, or shows that he is someone which he's actually not, and induces the mediator to pass an award. Such an award would not be passed. It is very closely linked to the implications of fraud. And fourth is the mediation conducted of disputes excluded under Schedule 1, which we previously discussed. That is those disputes which are categorically excluded from the purview of Mediation Act. I must also point out that the time limitation for filing an appeal against the mediated settlement agreement is 90 days. Now we come to a very important part of the Mediation Act, and that is online mediation. Why I say this is important is because it is a futuristic legislation. It is a futuristic legislation. It sees that in the coming future, most of the people would prefer to work from their homes, from the comfort of their homes. And therefore, they would not like to come out to fight someone and go to the court for that, or go to a center for that. And with passing time, online mediation, everything has become online, and and mediation might also become online. And it would also help enable the persons to resolve cross-border disputes, as Girija ma'am very rightly pointed out. So what happens in cross-border disputes is some party is sitting abroad, one party is sitting in India. And if there is no provision for online mediation, they'll have to wait for that party to come to India, or the Indian party along with the mediator to go to that place. And then they would sit there and mediate. Instead, online mediation has been introduced. So online mediation can be done at any stage of the mediation, including pre-litigation. However, it has to be with the written consent of the parties. It can be done through electronic form or computer networks, for example, through email service, secure chat rooms, audio video conferencing. However, it is responsibility of the mediator as well as the parties to maintain the integrity and confidentiality of the proceedings. Now we come to a very important portion, which is Mediation Council of India. This is a very fresh initiative and a welcome initiative, I must say. And it is provided under Chapter 8 of the Act. Its roles and functions I have delineated here. It promotes domestic and international mediation to make guidelines for continuous education and certification, assessment of mediators, provide manner for conduct of mediation proceedings, registration of mediators, renewal, withdrawal, suspension, cancellation of their licenses, lay down standards for professional and ethical conduct, hold trainings, workshops, courses, enter into memoranda of understanding and agreements, recognize mediation institutes, mediation service providers, maintain electronic depository of mediated settlement agreements made in India. So this is a council which has been established and which will be established at the central level, which would have a chairman, and if I'm not mistaken, six other members. And the mediation council would aim to act as a body which has to propagate mediation by all means. Propagation of mediation will occur in two ways. One is, of course, to promote it, to train people, to train mediators, to continuously educate them, certify them. But it will also occur through preparation of rules and regulations of mediation based on the Mediation Act. So most likely, Mediation Council is yet to be formed, although there are news reports that it will be formed by the end of this year. But whenever it is formed, most likely it will be the government or the central government would delegate the responsibility of making rules and regulations to the Mediation Council. And therefore, many rules and regulations will come into the picture, which would lay down standards for professional and ethical conduct of mediators, manner of conduct of mediation proceedings, how registration is to be sought, when registration is to be given, conditions of registration, and everything. So Mediation Council of India will be the pivotal body which will govern the mediation process in India. Then we come to mediation service providers. Now, mediation service providers, as per Section 40, is a body or an organization that provides for the conduct of mediation under this Act and rules and regulations made thereunder, and is recognized by the council. The council means the Mediation Council of India. So, mediation service providers will be bodies or organizations, as it points out, which will provide for conduct of mediation. That is to say that all mediation service providers will have a panel of mediators. And whenever any party, or let us say whenever two parties who wish to get their disputes mediated would come to a mediation service provider, he would file an application and the mediation service provider would assign them a mediator. Under the aegis of this mediation service provider and with the assistance of the assigned mediator, these parties can mediate. This becomes very important in context of those people and those parties who can't decide upon who has to be their mediator, or have any other disagreements. Those disagreements usually occur through many trust issues. Many parties do not believe that the mediator being suggested by the other party would be unbiased, would be neutral. So in such cases, they can always approach mediation service providers for the appointment of a mediator. There is also a list of deemed mediation service providers in the Act. This includes an authority constituted under the Legal Services Authority Act, which would be the legal services authorities. That could be State Legal Services Authority, District Legal Services Authority, and all of this. Then a court-annexed mediation center. For example, in Delhi High Court, we have Samadhan. So the Samadhan Mediation Center is a court-annexed mediation center, and it is a deemed mediation service provider. And any other body has been notified by the central government. Moving on, these are the functions of mediation service providers which have been provided in Section 41 of the Act. First is to accredit mediators and maintain panel of mediators. Second is provide the services of mediator for conduct of mediation. Third is provide all facilities, secretarial assistance, infrastructure for the efficient conduct of mediation. Fourth is promote professional and ethical conduct amongst mediators. And fifth is facilitate registration of mediated settlement agreements. So these are, I think, clear from the very language. So we'll move forward and we'll jump on to mediation institutes. Now, Mediation Institute remains a term which is yet to be very explicitly defined or dealt with in the Act. Uh, its definition is provided under Section 3L of the Act, which says Mediation Institute means a body or organization that provides training, continuous education, and certification of mediators and carries out such other functions under this Act. However, apart from this, mediation institutes have not been dealt with in much detail in the Act. From what we can gather from this very definition itself, is that it would be an institute so as to train the mediators, so as to ensure that the mediators are aware of the latest developments in mediation, latest tools and techniques and methods which are being used by mediators. It can also introduce uh, workshops. It can also introduce certification programs. And that is everything which will happen under the aegis of mediation institutes. However, we are yet to see what the Act and what the rules and regulations which are to be framed under it will entail with respect to mediation institutes. Then we come to community mediation, which is very important. Community mediation would mean uh, that any dispute which is likely to affect the peace, harmony or tranquility amongst the residents or families of any area can be settled through community mediation with prior consent, mutual consent of the parties. Now, for this, an application may firstly be made to Legal Services Authority, and if if an application cannot be made to Legal Services Authority, the same may either be made to a district magistrate or subdivisional magistrate. Now, in case of a community mediation, a 3 community mediators panel has to be established. That means there have to be 3 people on the panel which is undertaking community mediation. Those 3 people have to be people of standing and integrity who are respectable in the community. Any local person whose contribution to the society has been recognized, representative of the area or resident welfare associations, person having experience in the field of mediation, and any other person deemed appropriate. So the significance of community mediation, if I may say so, is that many a times disputes occur which are not interpersonal per se. That is to say, I may be in dispute with my friend. That is an interpersonal dispute. But then there are disputes at a larger scale. 2 or more families may be colliding with each other with respect to something. It may be a land, it may be an easementary dispute, or any dispute of such sort. Then there may be disputes which take a larger picture, which may be between communities or residents of a particular area. It may be a religious dispute. So community mediation can take place because, as I said at the very beginning, that the Mediation Act has kept its ambit very wide. So even such disputes can be integrated and brought within the umbrella of the Mediation Act. And therefore, such disputes can be mediated between the parties to avoid either from them to affect the peace, harmony and tranquility of the area or of the locality, and also from such disputes from reaching the court and taking much of the judicial time and also being delayed over time. So this is the purpose of community mediation. Now, that is all I would like to state for Mediation Act. Although I must also point out that at the moment, Mediation Act has not been implemented completely. On 9th October last year, a notification was issued by the central government by which a few sections of the Act were brought into effect. It was the Section 1, that is name, scope, extent of the Act. Section 3, that is definitions. Then it was Section 26, which states that the Mediation Act would not affect any proceedings under the which are undergoing in Lok Adalats or permanent Lok Adalats. Then Section 36 to 38 with respect to Mediation Council of India, and Section 45 to 47 which is with respect to mediation fund, accounts and audits of Mediation Council of India, and a few other miscellaneous sections. So all these sections have been brought into effect. However, one very important portion of the Mediation Act, which is not yet into the effect, but once it is brought into effect, will bring huge changes, is the ending portion, the fag end of the act, which seeks to amend a huge number of acts. Whenever Mediation Act is given its full effect, the Indian Contract Act, Civil Procedure Code, Legal Services Authority Act, Arbitration and Conciliation Act, MSME Act, Companies Act, Commercial Courts Act, and even Consumer Protection Act would all stand amended. In many of these acts, processes for settlements, mediations, or conciliation are already provided, and all of these would be integrated into the Mediation Act itself. In a few of these acts, the process of mediation would be introduced. So with that, I'm done with the portion related to Mediation Act. And now I would like to highlight a few things. First of all, I would like to come to Companies Act. As we all are aware, in the Companies Act, Section 442 provides for mediation and conciliation. And therefore, rules were framed thereunder, which were titled as Companies Mediation and Conciliation Rules 2016. Now, I believe that many people would have questions with respect to who can be a mediator, what can be his eligibility and everything. Although I believe that mediation is a process where parties have to decide the course. So if parties have to decide the course, they may even decide the mediator. So as far as I understand, there would not be many amendments to Section 8 and not very strict means of deciding a mediator or deciding the eligibility of a mediator will be put up. But we can take inference from Rule 4 of these mediation rules of 2016 that people of a stature are considered to be mediators. So under Section 442 and Rule 4 of this Act, a judge of Supreme Court, judge of High Court, district or session judge, member or registrar of tribunal constituted at national level, officer of Indian Corporate Law Services or Indian Legal Services with 15 years of experience, qualified legal practitioner for not less than 10 years, is or has been a professional for at least 15 years of continuous practice as chartered accountant, cost accountant, company secretary, member or president of any state consumer forum, expert in mediation or conciliation who has successfully undergone training in mediation or conciliation. So the legislature might take inference from these rules or other rules which are drafted or which are in effect with respect to mediation and conciliation to decide if eligibility is to be granted, a higher degree of eligibility is to be granted in certain cases. Such cases might be designated, but at the moment we do not have anything of this sort. Then I would also like to highlight a bit on how SEBI has integrated alternate dispute resolution and mediation into their procedures. One thing I told everyone about was the settlement proceedings regulations. In settlement proceeding regulations, if SEBI has asked a party to show cause regarding something and given notice to a party, all such disputes, all such allegations can be settled under the settlement regulations. However, there can be a case where there are interpersonal disputes between two parties. So for such cases, SEBI has introduced the ODR mechanism, which is the online dispute resolution mechanism. This was introduced last year in 2023. And there is also a scores portal. So scores and ODR have also been integrated now. And SEBI even gives the choice to the parties to either opt for its ODR portal or opt for an independent ADR institution. Further, to ensure that the mediator or the mediation process, settlement process remains neutral, remains unbiased, the ODR cases are assigned via round robin system. Why I also wanted to highlight this here is because all these things can be integrated in the Mediation Act also. So mediation service providers can also create a mechanism where cases are to be assigned via round robin system. Although the preference at the moment is given to the parties to select a mediator, but a mix of both can somehow be achieved, and it can be a suggestion which the legislative bodies can take to streamline the mediation. Further, SEBI has also streamlined the timelines for ODR and has provided strict timelines to complete the ODR process. Lastly, I would like to touch upon the statistics on mediation. So, these are the annual mediation statistics. And I must point out to the number of 39.4% of success rate. Cases referred were 49,126. This is from 1st January 2023 to 31st December 2023. A total of about 50,000 cases were referred. 16,000 of them were settled, and about 24,000 remained unsettled, which leads us to a success rate of about 40%. And I believe that having traveled all over these years, from Panchayat system to Industrial Disputes Act to Legal Services Authority Act, then to the Malimat Committee report, the amendment to CPC, thereafter to commercial courts, consumer protection. So in all these situations, mediation centers have arisen, have been established, and mediation has increased. So 40% is a very good success rate when we speak of mediation. However, I must also point out that in international scenario, especially in US and Europe, the success rates are between 60 to 80%. And the reason which we can attribute to such a higher success rate is stronger legal frameworks, greater awareness, and established mediation cultures. So this would also bring us to a very important point, which we were discussing earlier, which is of pre-litigation mediation. As I told you, under the current scheme of Mediation Act, the uh, pre-litigation mediation is a voluntary mechanism. It is not mandatory. So would it be changed in the future to ensure that more cases are settled in mediation? Because many a times parties believe that they can't settle things in mediation, but actually differences are minimal and they can be settled in mediation. So would this be the case or not is something which we need to ponder about, and something which the legislature would ponder about. But we need to establish a more robust system of uh, mediation. And with that, I thank everyone for giving me this opportunity, for giving me the time to speak, and all the audience members for being patient listeners.
Thank you, Siddhant. Thank you, Siddhant, for taking us through the new mediation law. Friends, we've already overshot by 16, 17 minutes. So I will not like to extend it further. I just say, just as a one line.
Agarwal Sahab, let me just first
Sure, sir.
pat the back of Siddhant for such so much of hard work. And very frankly, Siddhant, I would like you to share the PPT with me, because I have a lot to learn from your PPT. It is so exhaustive. I mean, very mature, and it's really that you need clapping from us, I think, for whatever you have done. And thank you so much for being so articulate and so to give so much of material to the viewers and participants. And fantastic. So please share the PPT with me so that I can share it with my team at least. And thank you, Agarwal Sahab, for giving this opportunity. You may continue, please.
So, as a matter of our own protocol, we share PPT with all the participants.
Great.
And all the panelists.
Very.
So we will share the PPT, certainly. And I must thank all the very, very learned panelists for sharing their invaluable experiences with us.
Girija, we can see you one last time, right?
Percentage will check.
Of course, we will meet tomorrow morning in the court, but
This will not match.
if you are still around.
Sir,
This
thank you very much.
This was on the while of discussion.
Thank you very much, Rakesh ji, Amit Khemka ji, Girija ji,
Thank you.
Siddhant. as a last line, although I had a lot to say, but I will say that we are on the right path. Once this council is set up, rules will also be specified. We have to travel quite a lot because under the new act, under the new law, there are two sets of provisions. One is where the central government has to prescribe certain rules. So I think along with the formation of the council, the central government will gradually prescribe all those rules. And there are a number of matters where the council, after it has been set up, has to specify the matters, the procedural details. So I think soon we are on the right track. And
What is important is also question number 20.
We will continue, I think, after the rules are notified and some of the council is set up and it specifies the further details. We'll have another webinar, a detailed webinar on this, and I'll request all the learned panelists to join us for that and share their experiences with us. Thank you very much. And friends,
With a promise, sir, with a promise that next time we will allow Mr. Ravi Prakash also to speak. You know?
In fact, I am fortunate enough to say and concede that Siddhant has spoken so well that I do not find a word to add or subtract. So I think that when you have already complimented him, I think that's the best compliment
That's a proud
any lawyer can
mentor.
get.
You know? That's a
Yeah.
proud mentor. Okay.
Friends, our journey of knowledge sharing will continue. And our next webinar, since 15th is a public holiday, so we'll have on Friday, the 22nd of October from 4 p.m. to 6 p.m.
November.
And yes, and our topic of the webinar is very interesting. It is on leaning out and group consolidation for organic growth. See, we discuss demergers, we discuss hiving offs and all those things. So we will see how organizations can grow, add value through leaning out and through consolidation of their processes, their products, their services, their offerings. Thank you very much and looking forward to your participation. And once again, a hearty thanks to all the very, very learned panelists who shared their invaluable experiences with us. Thank you very much.
Thank you.
Thank you, one and all.